Greetings, my fellow Americans, and welcome to another episode of the Great Montana Conspiracy Podcast. As always, if you're watching this on YouTube, please like and subscribe. Regardless of the platform you're on, please like, subscribe, and share. The more people we have viewing this content, the more information we get out there, the better effect and chances we have of affecting change. As always, if you are watching this in some capacity where you're not seeing the text content attached to this video, please either visit YouTube or monspiracy.podbean.com so you can actually get a look at what the subject matter of this is and any reference material. Like for instance, in this particular video, I'm going to be making a couple of attachments to the video, and I want you to be able to download them and read them if you choose to do so. Now, tonight's episode is something I've already talked about. Made a podcast about it a couple of weeks ago. Basically, this is revisiting the subject of Judge Heidi Ulbricht. This is actually the response to her order, to her rejection of my motion for early release. On January 20th, which today technically is January 21st, even though you'll be watching this on January 22nd going forward. So technically for me in this time, as I'm recording this was yesterday, that the motion was filed for rehearing and reconsideration. Now, I'll say this right up front. There's absolutely no chance she's ever going to grant this. I was not nice to her. I literally accused her of committing fraud on her own court. Just up front. But the reason why this motion was filed was not because I had an expectation of prevailing, but because the Supreme Court, as a court of review, cannot review an issue that the lower court has not had a chance to consider. Therefore, because this order was so vehemently outside the realm of anything that's standard or normal, I had to raise these issues and point them out to Heidi Ulbricht herself and say, look, these are your mistakes. Either fix them or is this going to appeal? I mean, I didn't say fix this or it's going to go to appeal, but that's basically the gist of the purpose of this motion. I have every expectation she's going to ignore it. That she's going to either just strike it down with some other ridiculously nonsensical reason, or she's just going to let it sit for 90 days and let it expire on its own. Either way, my expectation is this is not going to prevail because this is accusing her to admit that she made mistakes, and she never admits she makes mistakes, even when she does. I have sat in front of this woman and argued till I'm blue in the face practically. I mean, I remember one issue where she's talking about allegedly claiming that I have violated the Privacy and Communications Act because I have communicated content about my ex, Mara Jafrida, to her through the internet, and therefore I violated the law, Privacy and Communications Act. And I pointed out to her repeatedly, over and over and over in the courtroom, I talked about her on my blog. I did not communicate with her. I did not send her this information. This information was not sent to her. I did not communicate with her. I didn't have her email address or phone number, so how could I? Even Mara herself acknowledged I had not sent it to her, that it was sent to her by her friends. Her friends had found it, her friends sent it to her and brought her attention to it. At no point am I involved in that exchange. Yet Heidi Ulbricht ruled, despite the fact that I sat there and argued with her repeatedly that she clearly did not understand the concept under law of what contact means. She sat there and refused to give ground on it. And yet granted a restraining order claiming that just talking about her on my blog was somehow in violation of unwanted communications. There is no communication if you don't send content from one person to another. There is no communication. It just doesn't exist. Heidi Ulbricht ignored that and just barreled through and did what she wanted to do. Just like the first time when I was in front of her. She sat there and she tried to argue that it was that because Mara saw me at a bus stop and she saw me crossing the street, that I was stalking Mara. And that I was trying to find her address for purposes of serving her a legal paper. She actually, this is back when she was a municipal court justice, or municipal court judge, and she sat there and said, well, I find that Mr. Glick is guilty of violating the laws against stalking because, and then she trailed off and couldn't even come with an answer. She literally could not come up with an answer as to why. She just wanted to grant the motion. Now keep in mind, this is the hearing where Judge Ulbricht had ex parte communication with Mara before the hearing started, assuring Mara that she would grant the motion and grant the restraining order. So she already had it in her mind she was going to do this. She's already established for years that she's going to support Mara, she's not going to support me, and any chance she gets, she's going to impose restrictions on me because I am the person Mara needs protection from, even if Mara cannot produce a single element or justification for what she says. This is Ulbricht, putting her feet in the sand and refusing to move. Because even when you tell her you're sinking in quicksand, she will stay there because this is where she planted her feet. And she's right, and she'll be fine because this is what she does. The original motion I filed way back on December 2nd, it was, just to explain some history, it went 15 days. The state did not file a response. It went unopposed. The court clerk decided, well, we're going to reject it because it didn't have a proposed order attached to it. Now keep in mind, we all knew this was never going to be granted. So why a proposed order even need to be attached was ridiculous. Plus, the state would typically attach its own proposed order, which is what the court was going to adopt anyway. But the state didn't respond. And they certainly did not want the motion to go uncontested, so the court clerk found a technicality and said because there's no proposed order attached to it, then it gets rejected and you have to refile it with a proposed order. Instead of coming back and saying, there's no proposed order, can you submit a proposed order? And then allow the case to proceed. No, they rejected it because it didn't include it. That in and of itself demonstrates that the court wanted to give the state a chance to respond, felt the state had missed its window, and did not want to give an unfair advantage to me. Keep in mind, the law is written the way the law is written. Now, keep in mind, I had a conversation when I filed this motion to response, or this motion to rehear. The court clerk specifically told me this is only, the deputy court clerk, not Peg Allison, told me this is a policy that only is to pro se litigants. She specifically said, because you are pro se, any motion filed by pro se litigants must have a proposed order attached. Hello? Do you see a problem with that? So only if you represent yourself do you have to have a proposed order. If you have an attorney, no proposed order necessary. But if you represent yourself, violation of the 14th Amendment, equal protection of the law, equal access to the law, just a huge issue. Subject to another day, I'm getting off track. Basically, it was originally filed on December 2nd. It went 15 days, the state did not respond to it. Court clerk kicked it for a technicality. I refiled it. Again, 15 days went by. The state chose not to respond. The state had a 30-day window, 30 days, to respond to this motion. Twice as long as any other person in the state. The county attorney's office, who represents the state of Montana, had 30 days to respond to my motion. Did not respond in either instance. The motion went before Judge Ulbricht. The original motion was thereafter denied on January 5th of this year. As I previously attested, this order was a sharp deviation from reality, just absolutely a sharp deviation. It framed an agenda of propaganda and libel against me. Its only intention was to defame and misdirect and support justification to detain me. Nothing in the order made any sense because everything was taken out of context. The credibility of the individuals being quoted was obviously not substantial. It even took hearsay evidence and tried to say, okay, this is hearsay, and we're going to throw hearsay into this. Hearsay, of course, is where another person is testifying for someone else. One of the things that Dave Edwards, my first probation officer, did a lot in his pleadings was claim that he had met with my alleged victim over and over and over again. And yet my alleged victims never made a statement, never filed an affidavit, never testified in any capacity. The only person who ever has claimed in a court record, the only testimony allegedly coming from her is through Dave Edwards. And of course her mother. But again, Marja again, once again, my alleged victim has never made a statement, never come forth and objected to either my book, to my blog, to this podcast, to any filing I have made, nothing. Every presentation of my alleged victim's point of view and desire and how she's supposedly affected by anything has always been hearsay. Always. And hearsay is allowed because it's against me. But basically, you gotta remember the original charge was manufactured. They had to terrorize my alleged victim. They had to use undue influence. They had to take her from her home, had to tell her she's never going to go home if she doesn't cooperate. And how do I know this? Because her younger sister wrote a letter, or had her reading coach in school, was a high school student, write a letter and covertly bring it to her mother and say it and tell her that this is what was going on. They're threatening us. They're saying we can't go home unless we say things bad against Ron. This is reported directly from one of the people they were trying to turn. Of course, once they found out that Mara had gotten this letter, they cut off that line of communication. So it was a one-time deal. But she reported to her mother, Mom, Ron hasn't done anything. Ron's not a bad person. I'm not going to say anything bad against Ron. They're telling me I have to. I'm not going to. Well, my alleged victim didn't have the same constitution to resist the threats as her younger sister did. And she did bow and say whatever they wanted her to say. Change her story multiple times for them because the stories never added up, made sense. But this is all manufactured. The original allegations were manufactured, just like Ulbricht's summary of her justifications are manufactured. They're taken from concepts that should never have been used to justify anything because they lack foundation, they lack merit, they lack credibility, they're based on hearsay, they're based on speculation, they're based on an order of clearly unconstitutional restriction of freedom of speech. Clearly, I cannot even say the name of my alleged victim because I am barred by a court order telling me I can't say her name. It's unconstitutional. There's absolutely no justification for it. When the Supreme Court justified that order and ruled in favor of the lower court and said that it was somehow justified, they made it an uncitable opinion. A non-citable opinion, unpublished opinion, which could not be cited as precedent, could not be cited in justification. It was a self-contained order that was ruled against only me, which I will go into quite a bit here later on. But the point I'm trying to make is that in order to justify her position, she actually uses a non-citable opinion as a citation to justify. Because there's no foundation, there's no justification. Everything that was done was unconstitutional. Everyone knows it was unconstitutional, and no one wants to be able to allow it to be used as precedent for anybody else. Because if you start saying it's justifiable to tell someone they cannot have freedom of speech, you take that right away from everybody. Anybody can have their right of speech taken away from them if that becomes a presidential order. There's no way the Supreme Court is going to get into that mix. They're not going to deprive every single citizen in the state of Montana of the ability to speak someone's name. There's no way they're going to go there. They know this would be a huge conflagration, huge problem. They wouldn't be able to say people's names. No one would be able to say anyone's names. Everywhere you go across the state, across the country, everywhere, there's no way the U.S. Supreme Court would let that stand. Because that's what they want. They only want one person restricted, me. Because they don't like what I'm saying. And what I'm saying is truth they don't want out there. They wouldn't have to hide it if it wasn't the truth. They wouldn't have to hide it. But they do. But you have to understand, when a judge takes this order and makes a stand on completely unfounded principles, it skews everything. And that's why I feel I need to discuss this again here tonight. I want to discuss the bullet points of the motion. And again, I'm going to attach the motion and the exhibit to this video so that you can view it yourself. so you can read it in its entirety and its complexities and understand what I'm talking about. I'm going to be talking about it. I'm not going to read it verbatim. Read it. It's much more engaging, I'm sure, when you can actually read it line for line. As my producer points out, not everybody has the time or patience to read. So listening oftentimes is the medium by which people want to hear. And I get that, and I understand that. But if you want the details, I'm not hiding them. Unlike everybody else in this scenario, I'm not hiding anything. I'm putting it all out there. I'm not saying, oh, I said this, but you can't read what I wrote. Or I know I can take just part of it and then just hide the rest from you. You're going to get everything. I tell you the truth, I tell you the whole truth, and I make everything I say accessible. I'm going to back up what I say. I've always done that before the podcast. I'm doing this all this long after I stopped doing this podcast. The point is, it's who I am. And I'm not going to present something here that's not the truth, and I'm not going to back it up. If I have the ability to back it up, I will. And I'm going to back it up. So you're going to see that. And first of all, let me make it point clear here. Everyone involved in this case from day one knows this did not happen. They know I did not molest my alleged victim. They know I did not do anything inappropriate. They know. Just like Ulbricht knows that everything she just threw into this order was picked and chosen from a vast history, taking little snippets to justify her position. But these snippets are hearsay, they are conclusory, and they are cited from an non-citable opinion, because even the Supreme Court didn't want their opinion being published. Even the Supreme Court said, we do not want our opinion published because it's not constitutional. They didn't say that latter part, but that's essentially what they said. You don't have an unpublished opinion that says somebody that the court has the right to restrict someone's freedom of speech. You don't have a published opinion that says that. So they ruled in favor of the lower court by making it an unpublished opinion because they literally do not have to back that up. There's one court case that says, that I've been reading through and I cite it all the time. I just didn't make a note to bring it in front of me, so I can't cite the exact verbiage. But basically, it says the process of non-published opinions basically says the court can say this today, but is not bound by this decision tomorrow, nor is it bound by it at any point in the future, nor is it bound by what it said yesterday. It can say whatever it wants and change its opinion from day to day, applying the law on different standards between cases. And in the case of constitutional liberties, apply certain constitutional liberties to one person while denying it to somebody else. And that's essentially what they've done here. But in order to get this case to go through, in order to get this conviction against me, they had to threaten, terrorize witnesses, they had to cut me off from the world and my resources. And to this day, Judge Ulbricht, the very judge right here, will not let me into court to get my assets back. Mara Jafridi stole them. She took them for herself. Now keep in mind, we were partners. We were entitled to 50% of the business each. All I want is 50% of the assets and the value of those assets. She took them all. Judge Ulbricht will not let a case go and set a trial. The case was filed in 2007. It is now 2022. She has not let the case go to trial. She has blocked every attempt I have made to have her set the trial. I have pled directly in front of her. I have made pleadings. She's ignored them all. Because she just basically there's no compulsion to do so. The case has been open since 2007. 2007, ladies and gentlemen. She will not set a discovery schedule. She will not set a trial schedule because she knows if I get in front of a jury and I show the jury this is the Secretary of State's records, it shows I am the business owner. And she has nothing to show she's the business owner. The jury will have no choice but to recognize I'm the business owner. I'm entitled to the assets, not Mara. The only reason Mara has anything, now mind you, there is a partnership agreement. Mara won't produce it. Mara had all the business records when I went to prison. Part of the discovery would be produce those records. Now mind you, that's even assuming she still has the records after all this time. But part of the discovery would be produce that partnership agreement. Produce it. She won't, because her entire defense claims that she was the only business owner. It was her business entirely. She was entitled to everything. I had no claim in it. Then why was my name splattered across the Secretary of State's records and yours is not? And there's no way she could prevail in that case. And Ulbricht and all the cronies inside the Flathead County justice system, so-called justice system, don't want me to get access to my money. Why? I get access to hundreds of thousands of dollars. And by the way, when I went for a default judgment with interest, it's over $1 million in damages to this point. Over $1 million in damages because of the interest that's borne against these assets of this business that she took for herself, sold off lock, stock, and barrel for pennies on the dollar. She's never going to be required to pay it back so long as she never sees trial. And that's why Ulbricht allows all this stuff to happen. She allows Mara to go in and file frivolous restraining orders. She allows her to go in and defy every aspect. She allows the case to go just sit on the shelf and not go to trial. Because she knows if I go to trial and I get an order against her, they'll be enforced to go against Mara. Mara is a protected individual. And so long as she's protected, she's helping them. The moment Mara has to actually pay for her own crimes, Mara's no longer their ally. And there's no telling what Mara might actually turn and flip and actually come back and point out that the other side has done. Do I think it's going to happen? No, I think Mara's just blindly following the light at this point in time, and she realizes that she's in for a penny, in for a pound. But regardless, these people, the only way they're getting her allegiance and her assistance is because they are doing what they want her to do and penalizing me. And so long as they can keep this case out of the courts, they can keep me out of money. Because I can hire real attorneys, I can hire publicity, I can actually do a whole lot more than I'm doing right now with a little simple podcast in a room that I've set up as a studio. But as the motion sets forth, as my own motion right now sets forth, they are not above doing this again. The authorities are not above manufacturing false information to create this picture that they want personified. It's in how they skew the facts in this instance. It's a prime example of what they are capable of. I'm always fearful of retaliation. I'm always afraid they're going to make up something else to revoke me, and this is why. Because they're not bound by facts, they're not bound by the truth, they're not bound by the things that you and I are. They have an exemption. They can lie. I've talked about this before. They can lie. They can tell mistruths. They can say whatever they want to say because they're government. There's no consequences for them lying. If we lie to them, we go to jail. They lie to us, so what? No consequence. Keep lying, especially in a corrupt system that protects itself. This is why I'm fearful. Because they make stuff up. They take things, they exclude things, they find out what they want to say, and they present that out, and even though it's not justified, even though it's not rational, even though it clearly is not the truth, they get away with saying it. There's no consequences. Though it's a later point in the motion that I want to bring up something right up front. As I pointed out, the state has had 2 opportunities to respond to my original motion, a 30-day window collectively to respond to my motion. I originally filed this back at the beginning of December. The court clerk waited, struck it, I refiled it, another 15-day period passed. Still no response. There's no response from the state, no objection, no request to deny my motion, nothing. So Ulbricht stepped in up to it herself and basically took the position of arguing for the state, arguing for the county attorney's office, who chose not to make an argument. Pursuant to Rule 2C of the Montana Rules of Professional Conduct, and I'm going to quote this verbatim, failure to file an answer by the opposing party within the time allowed shall be deemed an admission that the motion is well taken. Just as it says just before that, the moving party's failure to file a brief shall be deemed an admission that the motion is without merit. So in other words, if I don't file a brief to support my motion, it must be considered without merit. Must, shall is a mandatory language. It must be considered. Shall, must are both mandatory languages. This verbiage is shall be deemed. Shall be deemed in both instances. If I don't file a brief in support of my motion, it shall be deemed to be filed without merit. Which means, guess what? My motion will be automatically denied. It has no merit. On the contrary, flip side, if the opposing party does not file a response, the motion must, or in this case, shall be considered well taken. In other words, there's no objection. It's true on its face. There's no objection, no request for opposition, nothing. It is well taken. It is agreed upon in absentia, which is basically what that means. In absence of a response or objection, there is no response or objection. An agreement in absentia, in essence. This is not discretionary. This is mandatory. This is something the court has to do pursuant to law. So when a court gets submitted a motion for relief and there is no objection, the court cannot then make an objection on its own. It's required by law to be considered that the motion is well taken. The motion must be granted. If there's no request to deny it, there's no objection to it, no opposition to it, the court, as an impartial party, is required to grant the motion. Instead, Ulbricht picked up the baton and made up the defense for the state. Now, keep in mind, I don't think Ulbricht actually wrote this motion. I don't. I think she had somebody else write it for her and she signed it. But regardless, it's her pen to the line, therefore it's Ulbricht's order. Remember, and now I'm going to point this out very specifically, pursuant to the Montana Canons of Judicial Ethics, which are the rules by which judges must comply within the state of Montana. Must comply. Rule 5, essential conduct. A judge should be temperate, attentive, patient, impartial, and since he is to administer the law and apply it to the facts, he should be studious of the principles of the law and diligent in endeavoring to ascertain the facts. That's a quote, verbatim, right from the Canons of Judicial Ethics. The important aspect of the critical word is impartial. Can't take one side or the other. Must be neutral, must be impartial. Cannot take up argument for one party over the other. Impartial means they do not take sides. They judge based on the facts that are presented to them. He should be studious of the principles of the law and diligent in endeavoring to ascertain the facts. The facts that are presented before the judge. I'm the only party that presented the facts, therefore my issues are the only ones that can be judged. It's right there. And you want to know how important this is? It's so important that the people who wrote the Canons of Judicial Ethics actually put it in twice. Yeah, that's right, twice. Rule 34, in relevant part, reinforces Rule 5. It says, and again I'm quoting, he should be conscientious, studious, thorough, courteous, patient, punctual, just, impartial, fearless of public clamor, regardless of public praise, and indifferent to private, political, or partisan influences. Once again, impartial is so important, they said it twice. Impartiality is so important, they put it in 2 separate rules. That's how important it is. And this one even adds the part that they're supposed to be indifferent to private, political, or partisan influences. They're not supposed to be influenced by the position that the state might have or the interests of the state. They should be interested in an impartial administration of justice. They can't take sides. Ulbricht took sides. Not only did she take sides, she argued for the other side. She acted as their attorney. She acted as their counsel. She gave legal advice to the state. Can't do that as a judge. You're not allowed to. It's barred. Except in Montana. They don't have to follow the law. It's so important they wrote it twice, but they don't have to follow it because they're Montanans. They don't have to follow anything. And clearly Ulbricht took up arguing for the state, even when the state did not do so itself. And it had two opportunities, 30 days, two 15-day windows, 30 days it had a chance to respond, and chose not to respond, chose not to object, chose not to request the motion be denied. The state didn't endorse it. They didn't come out and say, we endorse this, but they didn't object. They did not object. In a proper judicial impartiality, judges are only supposed to consider the issues raised by the parties in front of them. They're supposed to administer fair rulings based on facts presented for disposition. Yet time and again, Montana judges assert their own agendas into their rulings. Or, as in this case, they create arguments, they raise issues that are not brought up by the party they prefer. The party can't prevail upon the issues they're raising, so they will raise them for them. The judges will actually raise the issues for them, raise the law. You may not have considered this, but this is actually something that will help your case. You can't do that as a judge. Judges are impartial. They can't sit here and say, well, you know what? You should be raising this issue, because this issue is what really is the hinging issue here. I mean, they can sit there in their judgment and say, well, though no party raises this issue, this is an issue to consider. But the truth of the matter is, they're not supposed to sit here and make decisions. They're not. They're not supposed to side with one side or the other and say this is what's going on. They are required by law, by canons of judicial ethics, to be impartial. So where's the impartiality in this case, Judge Ulbricht? Or, ladies and gentlemen, where do you think her impartiality lies? Show me where it's impartial to take up judgment for somebody who's chosen not to plead, to take up arguments for the state. She's not a representative of the state. She does not represent the prosecution's office. She does not represent the Attorney General. She does not represent the governor. She represents the people as an impartial administrator of justice. Where's the justice? So when Ulbricht issued this order, it was not granting relief that was requested by the state of Montana through the county attorney's office. The state did not request relief. The state made no filing. It did not raise an objection. It did not endorse release. It did not object to release. The state did not request the motion to be denied. In fact, they did not file anything. They said nothing. They sat back and were silent. After an unprecedented 30-day window to respond, they said nothing. That's a choice, ladies and gentlemen. That isn't a missed deadline. That is a choice. You have two shots at this when you're only supposed to have one. They had two, and they still missed their mark. They chose not to. It was a choice. By law, since the opposing party did not respond twice, the court had to consider, shall consider the motion as well taken. And with no objection to the relief requested, she had to grant it. There's no objection. There's no request to deny it. There's no opposition of any kind. Except what I reported, which is hearsay. I can't testify for the state. I can't say what the state's position. I can say the state has told me that the state has indicated it objects to my release. But that's hearsay. I can't testify to what the state has to make its own objection. If I sit here and say, if I was suing somebody, I say in my pleadings, they refuse to give me money for what they owe me, I still have to go to court and prove that. It's a hearsay. My word that they said that to me is not something that can be ruled on. Unless they say nothing, in which case, of course, it's well taken. Then it's well taken and the court must consider it as true because they didn't object. It must be true. But in this case, it's hearsay. You can't base a decision and a ruling on hearsay. In correction in the last thing I just said, in the issue of if you go to court and I say this person refuses to pay me, the judge does not make the determination that that is a true statement. What they do is they say, well, they chose not to object, so we're going to order them to pay you. So they're not taking the statement that I say that they refuse to pay me as and validating it in some way. They're just giving me what I requested. So they grant it because there's no opposition. They're not saying, they're not endorsing the hearsay statement. It still remains hearsay. In this case, it's hearsay. I cannot testify to the state's position. I cannot swear I'm not a representative of the state. Believe me, I'm not a representative of the state. Can't do it. So in discussing the motion for rehearing, the first area of concern I had to raise in that response was the quote from Dave Edwards, my first PO. Now, keep in mind this PO set out from day one to force the confession from me. And I've testified to this in numerous court documents. It's public record. I made multiple reports to the DLC, I made multiple reports within the courts. He terrorized me constantly about throwing me back into prison if I don't confess to the crime of which I was convicted. He tried at least 2 times to set up revocation processes. He got one filed when he went to court after I tried to file my habeas corpus. The second one, he took my laptop. He came in, searched my laptop, found nothing wrong on it, took it, tried to have it examined by other law enforcement agencies. When he couldn't find other law enforcement agencies, he kept it back, trying to find somebody who could do something to it to prove that I would have committed a crime. The only reason why I got the laptop returned to me was because it was my nonprofit's laptop, which contained all my corporate records, all my nonprofits' annual filings and assessments. And the corporation, the nonprofit corporation, couldn't make an annual report without it. So the board of directors I was serving on sent a letter to the state and said this must be returned. And they returned it. Told Dave Edwards to return the laptop. He had to return the laptop. Of course, that ticked him off even more because his second attempt to revoke me failed. So that's when he went back to court and sought the modifications that she's quoting from. He tried to revoke me. It failed. He tried to set up a second revocation. It failed. He then went back to try to get me to voluntarily agree to these horrific additions to my restrictions, which are barred by court. State v. Field, State v. Hatfield. Look them up. I don't have the citations in front of me. Those are the 2 cases that are relevant. State v. Hatfield says that the DOC or the court cannot modify a judgment once it's made. Cannot go back and modify it. State v. Field says the court cannot give the DOC the power to modify someone's sentence. Both are state decisions, both are standards. These are issues that are forbidden by the state Supreme Court, but ignored in my case, obviously. But after we try to do this, it comes down to the issue that he went to the court and he tried dozens of modifications. And in those dozens of modifications, a few were granted. One of which was the limitations on my ability to say my alleged victim's name. Clearly infringement of civil liberty rights. State Supreme Court could only validate the modifications after, by making it a non-published and non-citable opinion. It's the only way. An unpublished opinion, non-citable opinion, was the only way they could validate it, because if they validated it in a published opinion, it would fly in the face of every freedom of speech doctrine out there. Every one. There's no way it's constitutional. There's no way it's allowable under law. And the only way they could do it is apply it to only me, and to make it stick against only me was to make it an unpublished opinion. I made several complaints about his misconduct, about his threats. I made public documentation of it. I quote much of it, by the way, not all of it, not even close to all of it, in the content of this motion. If you want to read it, I'm also attaching the original complaint, which those complaints are quoted from, which is the amended complaint to the federal suit I filed, which in a short Reader's Digest version got hampered down by the judges who were named in the lawsuit, shrunk down so badly that I couldn't proceed with it, really, tied me in a way that wouldn't allow me to proceed. I tried to pursue a RICO claim, and the court brought it down to just against Dave Edwards. And there's just no way to justify the RICO broader issue that was being sued and have it be limited and restricted to one person. Yes, his conduct was horrific. The court tied my hands in what I could say and what I could not do, and they did not appoint me counsel, would not give me any opportunities to get assistance of counsel. And of course, the state has every remedy at its disposal. It can hire however many attorneys it wants to. As I recall, there were like 3 attorneys sitting over there working against me. So, and by the way, please forgive, I do have a cold tonight, so I apologize for all the gruffness and the sniffling and all that kind of stuff. So, but at any rate, like I said, this eventually led to a federal lawsuit. Edwards had done his level best to revoke me or coerce a confession, and he'd failed. Every turn, the complaints I made were ignored. Long story short, that was what obstructed. It was obstructed by the federal district court and made untenable. I just could not proceed with the suit. I went to a jury trial, tried to prevail at the jury trial. The court actually told the jury that it could consider my prior conviction as a reason for not granting the relief. It has no relationship, but the court made that a condition the jury could rely on. So, we have to understand, before we go any further, an important fact here, underlying element of this. When you're talking about all these things that Dave Edwards was saying about me, all the court was saying about me, and everything else at that point in time, when they're trying to go through that first revocation, the second attempted one that didn't actually materialize, in the actual modification hearing, was that an important fact here is that there's a privilege against self-incrimination that survives post-conviction. There's a couple of key cases you might want to look up. Mitchell v. United States, which is a 1999 case. The actual notation for that is 526 U.S. 314. Once again, for anybody watching this for the first time, that's the 526th volume of the U.S. Court Reporter, page 314. There's also Minnesota v. Murphy, which is a 1973 case. That's 414 U.S. 70. Basically, the High Court decided between these two cases, and a host of other cases, these are two critical issues, that there are bars against self-incrimination existed. Self-incrimination, the Fifth Amendment privilege against testifying against yourself, continue to exist even after you were convicted of a crime, because you had appellate rights and you had the right against perjury. Especially if your defense, if you actually took the stand and swore you didn't commit a crime and you were still convicted, or you took an oath or swore in any public capacity that you didn't commit the crime and then later confessed to it, you could be up for perjury charges. In my case, at the time that Dave Edwards was trying to force this, I still had the right of writ of certiorari from the United States Supreme Court, which he sabotaged by trying to revoke me, because the 2 months I was in jail trying to fight the revocation, my time period for filing a writ of certiorari expired, and the United States Supreme Court would not grant me an extension after the fact. So that right was lost to me because of the revocation attempt. But I also had sentence review, and I had post-conviction relief available to me, all of which were manipulated away from me, which is another issue entirely, but that's beside the point. The issue comes down that I still had appellate rights in front of me. Therefore, he could not compel me to say that I did something I did not do. He could not coerce me or threaten me to get me to comply. It was unconstitutional. The United States Supreme Court has said so. But also, since I have sworn in multiple affidavits, multiple pleadings in court, multiple processes in courts of law across the state, that I did not commit this crime, if he coerced me, I actually succumbed to the threat that he was imposing upon me and said what he wanted me to say in order to avoid further retaliations, to avoid further hardships, then my declaration of my innocence would work against me, and he could actually get me for perjury. He could actually have me perjured because one of the statements, and under the law, by the way, it's not necessary to prove which statement is true, only that they both cannot be true. Therefore, all he had to do was get me to say I had committed this crime. He didn't have to prove whether the later statement was true or the earlier statement was true, only that they both could not be true, and therefore it's perjury. Consequently, if he had compelled me through coercion to confess to this crime of which I have repeatedly in court documents and under oath in multiple occasions sworn my innocence to, then I'd be subjecting myself to prosecution for perjury. So, of course this is what he wanted. He wanted to be able to, and of course under Montana, because the moment I commit another crime, I go back to prison for 15 years. Even if he couldn't revoke me, he could throw me back in prison just for the perjury. Just for the perjury, he could throw me back in prison for another 15 years. So the risk of consequences were horrific. But he was allowed to do it, and every complaint I made was ignored and disregarded. But the quote from Ulbricht's response was from the attempt to modify. It wasn't even from the original revocation attempt. She doesn't mention the original revocation attempt. She doesn't mention the complaints made to the DOC against Dave Edwards' conduct. She doesn't mention the federal lawsuit brought against Dave Edwards for his misconduct. She deliberately leaves out all this prehistory, leaves out all the misconduct reported, just cites Dave Edwards' statement, which, by the way, was hearsay, because in that statement he goes on and on about allegedly what my alleged victim is saying and what my alleged victim is feeling, but there's no statement, sworn or otherwise, from my alleged victim declaring this. It's hearsay. The alleged victim reports this, the alleged victim reports that. It's hearsay. The alleged victim must come forward and say what this is. The court cannot accept hearsay. Didn't do it. That was one issue, by the way, I did not have time to actually write in. I wrote in a 15-page document in my motion for rehearing, and I was running out of time. Even though there is no standard in Montana for what a rehearing reconsideration motion is, there is a standard for the Supreme Court, which is 15 days. And that tends to be the model. 15 days from the date of judgment to issue a rehearing or reconsideration request. So that's what I complied with. So, and that 15 days expired after yesterday, after the 20th of January. So I didn't have time to keep putting in more and more stuff in there. I probably could have written a 30-page document with everything that was wrong. I tried to stick to the biggest key issues. So I didn't bring up the hearsay. Probably should have, but did not. But when you leave out the part of the escalating levels of harassment, you leave out the complaints made about this or the public records about this, it makes the allegation that was presented by Ulbricht out of context. And you don't present the context in which it was made. This was a statement made after 2 attempts to revoke me fell apart, one of which was filed with the court, one of which was ordered to be stopped by the DOC, which was the seizure of my laptop, trying to find a way to use the laptop against me. In frustration of not being able to revoke me, he wanted to impose harsher penalties over to make it easier to revoke me. Now keep in mind, one of the conditions he tried to impose was that I could not go any place there was a reasonable expectation that a child could be present. That is literally anywhere. Thankfully, that was not a condition the court adopted. But that's how stringent he was trying to be. He was trying to tell me I couldn't go to movie theaters, I couldn't go to hospitals, I couldn't go to the emergency room, I couldn't go. He literally was trying to cut me off the knees and tell me that you cannot go literally anywhere, because if I find you out on the street, I'm going to throw you in prison. If I find you anywhere but your own home, you're going to prison. Literally, that was what he was trying to do. Thankfully, the court did not adopt that stringent approach when they did modify my petitions, but nevertheless, he tried. And Ulbricht ignored that entirely. Ignores how extreme he wanted the restrictions to be. The very fact that they adopted a clearly unconstitutional limitation on me, saying I cannot speak someone's name, is bad enough. But the whole range of conditions he wanted to impose that were not granted were horrific. But again, because it's taken out of context, because it's not taken in the light of which it was said, or the conditions under which it was said, his bias, his motivations, his justifications, everything was falling apart. He made these wild efforts to just put the most restricted things he could think upon me. And I've used the t-shirt analogy before. If you have a black t-shirt and you have white lettering on the t-shirt, you cannot call a t-shirt or testify under law. It's a white t-shirt. It's not a white t-shirt. It's a black and white t-shirt, but it's not a white t-shirt. It's not wholly white. Therefore, if you present only part of the story, it's not a true statement. By taking this one little segment, this very biased, very prejudiced, very motivated statement was designed to present me in the worst possible light, based on hearsay, based upon the malice of the individual who's already demonstrated horrific malice against me. That's the statement you take and you present it out of context to make it appear that this was the problem. This wasn't the problem. The problem was the person who took it upon himself to abuse his position of authority to try to compel a person who had maintained their innocence of a crime to confess. Was he looking for brownie points, promotions? I don't know. I don't know his reasonings, but for lack of a better way of saying it, he had a hard-on for making me confess. Now, mind you, I've had like 5 probation officers. He's the only probation officer who ever went to that level. Ever went to that level. Ever, ever, ever. Even when the second revocation attempt came up and Brock O'Hara was my probation officer, it was his bosses who told him to do it. He didn't do it. He didn't do it on his own. He was quite satisfied with me doing what he asked me to do. He found the name of my alleged victim inside the book. He pointed it out to me. I fixed it within a couple hours. Sent him a copy to prove it, and he was satisfied that that was taken care of. It was his bosses. And mind you, his bosses were pushed by Marge or Frida, who, remember, ladies and gentlemen, wanted me off the street because she didn't want to answer the lawsuit. Ulbricht knows this. She even cites it. She cites that the mother of the alleged victim came in and talked to Brock O'Hara and his boss, brought this matter to their attention, wanted me revoked. Ladies and gentlemen, that's the problem. You take things and you take them out of context and you put them in a way that makes it look like it's something that it's not. And that's clearly what's going on. But you're taking the quote of an overzealous probation officer who had public complaints made against him, who had a federal lawsuit filed against him, and that's your litmus test. In effect, Ulbricht was trying to use this very libelous statement to seek to condemn me for constitutional freedom of speech. Keep in mind, I didn't have any restrictions on my freedom of speech at that point in time. I was not restricted. I could say whatever I wanted. But the position that it was supposedly somehow damaging to my alleged victim was all hearsay. Yet, Ulbricht is presenting it as fact and true, ignoring the hearsay component. Next, Ulbricht goes after the second revocation. And she specifically brings up, and remember, this was a failed revocation. I prevailed. I was acquitted of the revocation attempt. I was exonerated because Ulbricht herself determined that I had already been sanctioned. Per double jeopardy standards, the probation office could not sanction me and then turn around or punish me in some way or demand some kind of a compliance and then turn around and revoke me on the same issue. By the standards of law, the moment they came to me and said, you must fix this book or you will be revoked, I fixed the book because it was an accident. I didn't know it was there. It never my intention to have the name there at all. When it was discovered, I fixed it immediately. No objections, nothing. Just, it's not deliberate. It's not my intention. But Ulbricht never ruled on whether the act was deliberate, only that I had been already punished for the act. Didn't declare it was a justified act, that the act was deliberate, nothing. And the mens rea argument was presented before her. In fact, I even quote the mens rea argument inside the motion, if you want to read it, from the original pleading filed by Nick Amasager, my attorney at the second revocation. Here she seeks to identify the inclusion of my alleged victim's name as deliberate. That somehow I had deliberately violated my rules of probation. She had the opportunity to rule on this issue and did not. She sidestepped it. Mens rea, just to clarify for anyone who hasn't heard my previous explanations of it, it's basically, it's a crime based on a punishable act that it must be deliberate. You must choose to do it. It must be a choice. I choose to steal that candy bar. I choose to shoot that man. I choose. Mens rea is a component of any criminal act because it requires intention to commit the crime. Mens rea actually translates from Latin literally to guilty mind. You have to prove that the person who committed the act did so with a guilty mind and an intention to do so. An intention to commit the crime. I used the example before. If I go out and start my car and the car blows up and people are hit by shrapnel and 3 people die, am I somehow guilty of murder? Well, no, I did not deliberately turn my car into a bomb and deliberately shoot shrapnel at people. I just turned on my car, it blew up. No mens rea. No deliberate intent. When I missed a name appearing out of thousands of redactions that surrounded it, how could you say I did that deliberately? Because I didn't. But how can you? I mean, the only person who found it was Mara, who was trying to find a reason to have me thrown back into prison so I would not be able to continue my lawsuit against her. Her conflict of interest, her motivation was never, they always just took advantage of it. She doesn't want to be sued. She doesn't want to pay back what she stole. She doesn't want to be held accountable under law. So she's our ally because we also don't like Glick. We also don't want him to have access to his assets. We also don't want him to have money to fight us with. So let's keep supporting her, and regardless of how ridiculously unsupportable her positions are, or clearly prejudiced her motivations are. She found out I was filing this motion. She found out I was filing this motion for early release. She ran to, my probation officer's words were that she called up in a tizzy. I believe that was his word, tizzy, I believe. She called up all frenzied about how I'd supposedly been stalking her dad's place. Anyone who knows the previous stories knows that she set up cameras because her neighbor is one of my oldest friends. I consider her a sister. I've just known her forever, and it was since 2000. And she has been there through me through all of this. She's been a rock, helped me through a lot of this. My friend Jean Fox just happens to be neighbors with Mara. Knows I go over to see my friend. Sets up her camera so she can watch my call, watch for me to approach. And then once she realizes I'm visiting Jean, she'll call and claim that I'm harassing her. She knows I'm not there to see her. She knows nothing. She's just looking for excuses. I have literally had to make a choice, even though there's no active restraining order in effect right now. I know if I go out and see my friend Jean, if I go out to help her, if I go out to make dinner for her, if I go out to pick her up, take her to the grocery store, and Jean does have health issues, where after all this time, she does have health issues, and she needs help from time to time. If I go out there to give her help or render aid or just visit with my friend and watch TV for a night, I know Mara's going to be calling up all her friends in the probation office, calling up all her friends in the county attorney's office, calling up her friends in the sheriff's department, and trying to claim them out there harassing her, even though she knows that I'm not doing anything of the sort. She just wants an excuse to get me thrown in jail. She wants an excuse to throw me back into prison. And so she makes up all this garbage, and Ulbricht knows this. I keep saying that Ulbricht's stupid because she doesn't know the law. She sits here and she actually tries to justify things that are clearly just so far afield. She doesn't understand the law. Either she's really good at acting stupid or she's stupid because she doesn't know anything when it comes to, she just basically does whatever she can. She abuses her power without even knowing what the limits of the law are. But she knows that Mara's lying. She knows I'm not doing anything to harass Mara. She knows, she knows, she knows. This is common sense. Okay? She can tell that Mara's making this stuff up. But she's so biased, she's so prejudiced, that she will find a reason to grant Mara's relief over me. Just the way it is. I know this. So I deliberately stay away from my own friend's house, my friend of 20 plus years, because I know Mara will make up something if I try. So she can't get me on camera because I'm not going out there anymore. I can't because I know she's just going to make something up. So then she goes, she can't tell my probation officer I'm harassing her anymore, so now she makes up this story that I'm harassing her dad. I'm going after her dad's property because her dad's property doesn't have cameras, so it's all he said, she said. Claims I'm out there somehow, I don't know, something about someone living there and moving out and wanting property. I don't know the whole story. I just completely don't know the story because I just know just these bits and pieces my probation officer brought up. But the reason why she did this was because she found out I was trying to get early release. She found out, and as a consequence, she decided to start making up stories again. Thank you, my probation officer. My probation officer is so lax. He's like, eh. he couldn't care less. Because I think he knows. Brock O'Hara knew. Brock O'Hara only pursued the revocation because his bosses told him to. He didn't pursue it because he genuinely believed I was guilty of any of this. He did what his bosses told him to do. Which unfortunately makes him just as guilty as the rest of the participants in the Great Montana Conspiracy. So if you're just going ahead and cooperate with the corrupt people, you're still corrupt. It doesn't matter whether you're the person who's actually behind it or you're just doing following the orders of the people who are telling you. I mean, that was a great defense of Nazi Germany, wasn't it? All these military people on trial in Switzerland, at the Nuremberg trials. To a man, I was just following orders, just following orders, just following orders. They still got convicted, didn't they? Just following orders is not a justifiable defense. And yet, this is what these people will constantly claim. I'm just following orders. Brock O'Hara's defense would be, in his memoirs, he was just following orders. But that's the same excuse that the Nazi Germany officers tried to use, and it failed in Nuremberg. It fails at a common sense range. On an ethical grounds, you know what's right, you know what's wrong. You know when you're lying, you know when you're telling the truth. And if you have to lie to advance a cause, then there's something wrong with your cause. Isn't there? Shouldn't there be? The point is, going back to the original subject as it got deviated, and the mens rea issue, the idea is that this argument was made to Ulbricht during the second revocation attempt. She sidestepped it. She chose not to rule on it whatsoever. She avoided the issue at the time that it was something I deliberately intended to do. She chose not to rule on that. She just accepted that I had been punished already and dismissed the revocation. This means she cannot now go back and say I deliberately breached term of probation, because when it was presented to her to make that choice, she declined to do so. Once again, it's essentially an element of consent abstention, because she's basically saying, I can't argue that. I can't argue it was deliberate or not deliberate. Therefore, I'm going to choose not to discuss it at all. I'm just going to grant or deny it on other grounds altogether. She had the chance. She declined to rule on it. She cannot come back now and make like she did. She didn't. She knows it was a non-deliberate act. She knows it was unintentional. And she can't say, I deliberately violated the term of probation. The only sanction out of 13 years of supervision was an act that wasn't even deliberate. And she knows it, but she's got to try to build it up. She spends roughly 2/3 of her order building this up. Then after this, she seeks to justify all this by citing the Supreme Court's order affirming the decision of the other issue. And she says Supreme Court did find that the freedom of speech restriction was proper. But as I mentioned, they do it through a non-citable opinion. They do it through an unpublished decision. The specific language of that order is, and I'm going to read it verbatim, pursuant to Section 1, Paragraph 3C, Montana Supreme Court Internal Operating Rules, this case is decided by memorandum of opinion and shall not be cited and does not serve as precedent. The Supreme Court made this a non-citable opinion. It is non-citable, it cannot serve as precedent. And what did Ulbricht do? To justify her position, to try to put the nail in the coffin, to justify that everything that was done was signed off on by the Supreme Court, cites a non-citable opinion. This only meant the Supreme Court could not justify the unconstitutional deprivation of freedom of speech without making those restrictions apply to anyone but me. So they made an unpublished opinion. They made it a non-citable opinion because they knew it could not stand if it applied to everybody, because they knew this was unconstitutional. There's absolutely no way that restricting someone from saying someone else's name is constitutional. No way. None. Zero. Nada. I have the right to speak. I have the right to say names. This was done when Robert Allison, we were talking about him a while ago. In a previous one, we're talking about pre-trial publicity. Judge Allison was overseeing Bradley's case, and sitting there and deciding that earlier when I was Angela Townsend was sorry. This all gets me a little bit anxious. I mean, there's an anxiety that's building, because I'm talking about my own stuff. It brings up bad memories, it brings up bad feelings, the unfairness of it all. And I have to stop sometimes to take deep breaths, and I have to try to keep myself moving forward. Because if I slow down too much, I'm just going to crash. I'm trying not to do that. So please forgive. But basically, when, and again, I apologize. I'm really trying to get through this. I'm trying not to collapse here. But when Angela Townsend brought her own restraining order against me, that restraining order was to stop me from using the name The Forewarned, which was the title I had created for her, that she used, that she stole a trademark of, that I had filed a federal trademark suit against her for its use. She ran to the state district court in front of Judge Allison and had him order me not to be able to use the name. Again, horrific restriction of civil liberties. Again, the state Supreme Court came back with a non-citable opinion saying it was justified to bar me from using that name, even though it was my name. I created it. I was disputing in federal court. State court technically had no jurisdiction, but Montana does whatever it wants to do. But everybody knew it was unconstitutional. Everyone knew it was. The high court knew it. The district court knew it. All the attorneys knew it. Everybody knew it. But they figured I could not help myself. And believe me, I've slipped several times in interviews. And there's been times I've been talking on my podcast. I've had to stop recording my podcast because I've mentioned her name. And so I have to stop, go back, and record and then clip together because I made the mistake of slipping and saying her name. They figured I could not help myself, and that was a good way to get me back in prison. And then they found one instance where I accidentally slipped and left it in my published book, U.S. Political Prisoner since 2004. So yeah, they figured that sooner or later I was going to slip and they could revoke me, and they jumped on it. They tried. It failed. It fell apart. But they tried. The point was the the underlying restriction. It was raised by my attorney at the time, Nick Amiseger, in my second revocation. Again, another issue that Ulbricht sidestepped. She didn't want to talk about it. She didn't want to deal with it. The state didn't want to argue against it. They knew there was no foundation for it. They knew there was no arguing against it. They sidestepped discussing it. Ulbricht sidestepped ruling on it. And now she wants to come back and rely on it. You can't sidestep an issue and then come back and decide and act like you decided in favor of it. You didn't. You were asked to make a decision on it. You chose not to. Consent by absentia. But then you come back and make like you did. Well, this is the problem with this order all around. It's all based upon things that aren't factual, aren't true, and she treats them like they are. Because who stands up to her? Nobody stands up to her. And people who do stand up to her end up like me. Not saying that she's behind the original political imprisonment, just that she's helping to enforce it. She's helping keeping it in place. Basically, the majority of the reasoning of this order, it's based on hearsay. It's based on prejudicial, unbiased pleadings. It's based on deliberate misrepresentations of fact, saying things that aren't true, and acts for which I've been acquitted. Even the restraining orders, when she brings up the restraining orders, she claims that there were violations of the restraining orders. There were no violations of restraining orders. She ignores that the restraining orders were filed by people who had pending litigation. I was trying to resolve the issues through the proper legal channels. And did not private. She won't even let the lawsuit, the very lawsuit that was the impetus of the restraining orders, go to a jury. 2007, ladies and gentlemen. It's now 2022. Still doesn't let this go through. We're closing in on 15 years. It's 14 years now since this whole thing started with the lawsuit, and they won't let it go through. Why? That's because they know if it goes in front of a jury, I will prevail. They know. There's no way. The only thing she could possibly present is her own statement claiming the business was hers. She has no documentation. I have the documentation. She has no record. The only record she would have would if she actually produced the partnership agreement between us, which she claims doesn't exist because she claims the business was hers. Entirely hers. There was no partnership agreement. She won't produce anything because everything she could produce would contradict her own testimony. She can't go in front of a jury and claim that it was her business if she didn't file anything with the Secretary of State. I filed it all. Nothing was in her name. So how does she claim it's her own business? Because the court just ignores it. And the court knows they put me in front of a jury of 12 people. They're going to look at it and go, business is in his name. She can't produce any proof it's hers. They decide in my favor, and Ulbricht doesn't want that, let that happen. Once again, impartiality. Like I said, because she goes into this issue of the restraining orders, and she ignores the foundations of which they were sought. She ignores the background. She ignores everything because she ignores everything as routine, so long as it penalizes me. And she summarizes it in a way that makes it sound like I'm a threat to society because these restraining orders were sought and obtained. And then she claims they violated them, which never happened. But incidentally, my probation, who's supposed to be supervising me for conduct, one of my conditions is I must remain law-abiding. If I had violated restraining orders, that's not law-abiding. That's a criminal offense. I'd be back in prison. They never took issue with it. That's for all the troubles I've had with the probation office, by the way. They've never tried to cite me or punish me for having a restraining order, except for Dave Edwards. The very first restraining order was because Dave Edwards told Mara she needed to get one. That's how she got a restraining order. Glick's trying to find you. You need to get a restraining order. He knew I was trying to find her because I was trying to get her served. He knew this. He didn't want, just like the court, just like Heidi Ulbricht, he did not want the lawsuit to come to fruition. He did not want me to serve Mara because he did not want me to gain traction in my financial resources back. So he tried to make sure that I couldn't serve her he told her to go to the court to get a restraining order to stop it. That's why the first restraining order even happened, was because he told her to do it. Again, I've talked about that probably too much. Anyway, the point I'm trying to make here is that all these TROs, temporary restraining orders, whatever you want to call them, they all occurred because these people committed acts that were suable. And their solution to trying to deal with a lawsuit and being sued was to get a restraining order to restrict me from getting to them to serve them. They openly stated as much in every proceeding. They were all surrounded by made-up facts and details which could not be substantiated. But it didn't matter because, once again, I'm the bad guy. I'm the one who needs to be put down. And these courts will make sure that any decision that's ruled in court that they have control over will be ruled against me. Ulbricht knows if I go in front of a jury, it's not something she can control. That's why they won't let it go to trial. Because then it's out of her hands. It's out of the hands of the corrupt officials. It's in front of 12 people that they cannot control. Of a special note here, as I mentioned, probation office didn't take issue here. The probation office never sought revocation, never sanctioned me, never anything for these restraining orders. So what does that say? If the probation office, which is responsible for overseeing my conduct in the community, had no issues, why does the court have an issue? And once again, the state did not make this objection, the state did not raise these issues, the state did not oppose my motion in any way. This is all right, taking whatever details she can to try to create an illusion of risk. An illusion. And she knows that all these restraining orders are bogus. She knows it. She doesn't care because she can use them as weapons. By my reporting, it's just, I mean, I keep saying this over and over again, but you don't have to have the law on your side if you're in Montana. You just have to be rich, elite, or be in a position of power and do whatever you want. Ulbricht has issued orders she knows are not based on anything other than the fact that she starts off with a reputation of being a man-hater. She sees a woman who walks in and claims to be threatened, and she sides with her. And then she digs her feet in the sand, no matter how much evidence is presented to the contrary to disprove that, she's already made up her mind. She made up her mind before that first hearing, that first restraining order, and that's where it stands. She's never shifted from that, regardless of how much evidence is presented of the malfeasance, misconduct, the lies, everything. She ignores it. And then she uses those very arguments and those very judgments to substantiate her claim that I'm a threat. She knows I'm not a threat. She knows this. But she can't break from the flock. She can't break from the pack. She's part of the good old boy system. When the time comes to object, the state is silent. The state doesn't raise issue about the restraining orders. The state doesn't raise issue about allegedly what Dave Edwards said. The state doesn't raise issues about the failed revocation attempt, and certainly doesn't raise issue about what the state Supreme Court ruled. None of this is all Ulbricht. When it came time to object, the state said nothing. My reporting that the state opposed this is at best hearsay, because I can't testify for the state. Therefore, stating that I said and I acknowledge the state opposed this outside the courtroom is not admissible as evidence of the state's position, because the state has to testify for itself through the county attorney's office. I can't plead for the state. I cannot present something for the state. Yet my statement was used against me, and Blake acknowledges that the state opposes this position. Yeah, I said the state told me that it opposes the position. That's hearsay. Once again, had to pick and choose. After 15 pages, I pretty much had to end my pleading, but that was an issue I probably should have raised and didn't, because I ran out of time and I was already taking up way too much space. It shouldn't have been admissible statement. It should not have been admissible testimony, but it was, because Ulbricht doesn't follow the law. Again, apologies, I'm almost at the end. I'm trying to get through this. All of this basically boils down to fraud of the court, by the court itself. Several cases support this. I'm going to read some summaries directly from my pleading. A court can commit fraud upon itself through its own misconduct. United States v. Manton, 107 Federal 2nd, 834. That's the Second Circuit Court, a 1938 case. Fraud in the court is, quote, where the court or a member is corrupted or influence is attempted, or where the judge has not performed his judicial function, thus where the impartial functions of the court have been directly corrupted. See Robinson v. Audi Aiken-Selschaft. Hope I'm saying that. I'm probably not even close to saying that right. 56 Federal 3rd, 1259. That quote was particularly at page 1266. It's a 10th Circuit case, 1995, citing Bullock v. United States, which is 763 Federal 2nd edition, page 1115, and that actual quote comes from page 1121. Again, a 10th Circuit case from 1995. Certiorari on that particular case was denied, as of 116 Supreme Court 705, 1996. Fraud violates everything it touches and destroys the very thing which it is devised to support. King v. Horizon Corporations, 701 Federal 2nd, page 1313. That's a 10th Circuit case, 1983. So those are some cases to consider and review if you wish to review them. Just so you know, and as I said, I will be attaching the actual pleadings as links to this. If you don't find those pleadings, if you're watching this video in some capacity in which you're not seeing those links, by all means, please go to YouTube or monspiracy.podbean.com to watch them. In closing, I want to make a point here and make it very clear, and I hope that as I tried to hold myself together as I presented this tonight, as always, this is very scary for me. I am calling out criminal misconduct yet again. Calling out criminal misconduct is what got me in this position. Calling out criminal misconduct by police officers in Kalispell, Montana got me where I am. This is what got me in prison as a political prisoner in the first place. So keep good thoughts aimed my way, and let's hope that I remain free to continue with these podcasts. In closing, as always, please be safe, and whenever possible, please be free. Thank you.